rise. Court of Appeals District 1 is now in session.
Morning, please be seated. All right, we are now here for CV 22-0142 Shooter versus State et al. As you may know, we record and are currently live streaming these proceedings, so if you stand up to argue, please announce for yourself and your client. You have a maximum of 20 minutes per side. I see that we have several folks on this side, so I will leave it to you to allocate your time however you choose to allocate your time. And if you would like to save time for rebuttal, that is, again, on you to save that time. Neither side is required to use all of the 20 minutes, although you do have it available should you decide that you need it. Keep in mind, we have read the briefs, we've studied the record, we discussed the case this morning in conference, and with that, please proceed.
This was out last time, so I apologize. Good morning, Your Honors. Ross Meyer on behalf of Appellant Donald Shooter. So this case has been going on for a number of years, and it stems from the tarnishing of the reputation of a legislator that has long been a fixture in Arizona representing Yuma. And here in the mid-2010s, then Senator Shooter, but Representative Shooter, found some indiscrepancies with the state budgeting process and the award of contracts that he felt violated Arizona principles. Upon doing his legislative duty, investigating, introducing House bills and Senate bills, he felt that he was expelled from the legislature for those investigations, for those actions. And in that process of being expelled from the legislature, the issue here is whether the Arizona Constitution was followed. And so there's a few claims which you've read. It's been to the Supreme Court on issues, and the issues here are the notice of claim, and whether the claims that were pled in the amended complaint were in the notice of claim. And then secondly, and that has caveats and issues within it there, but then secondly, whether there is a stigma plus claim in Arizona that can be brought by plaintiffs. And
Counsel, if I could interrupt you for a second, because you mentioned the notice of claim. The Superior Court's order said, I'm granting the summary judgment as a defamation claim, and I'm not quoting because I don't have it in front of me right now, but I'm granting summary judgment as to the defamation claim, one, for the notice of claim, and two, because it violated or didn't comply with the statute of limitations under 12-821. And then it said these are separate and independent bases for granting the summary judgment. I've reviewed your opening brief pretty carefully, and you respond pretty persuasively to the notice of claim portion of that. I don't see anything in the opening brief that addresses the statute of limitations portion. In reply, you mentioned, well, you at least make some argument that because the initial complaint at least references the press release, that therefore it can relate back. I get that argument, but we are usually pretty strict with parties about if you don't raise something in your opening brief, you've waived it. Why hasn't the defamation claim, summary judgment as a defamation claim, been waived as to the statute of limitations argument?
yeah, and there that argument is, so one, you mentioned my rule-based argument that's laid out in the reply based on the relating back. In terms of waiver, the notice of claim was brought up as an issue, and that the Superior Court's...
But the notice of claim and the statute of limitations are two separate, independent grounds. So if you could answer Judge Morse's question without commenting on the notice of claim, but explain to us how you have not waived the statute of limitations argument.
I will address this very clearly in my rebuttal. I will pinpoint, but let me answer this. The opening brief clearly articulated that the court's summary judgment motion on this issue was incorrect on a legal basis, which would include both of the reasons, the independent reasons that the Superior Court reached in this matter.
All right, and on rebuttal, you'll come back and point me to some specifics?
Yes, yes,
Thank you.
exactly. But that makes sense, and I hear the court on that, so I will do that on rebuttal.
But let me build on that
Yes.
for a second, because before you get into the stigma plus, or as a transition to stigma plus, let's assume, for argument's sake, that we find that it was waived and your claim on defamation is barred by 821 as a matter of law. Where does that take, just for assumption, okay, hypothetically, where does that leave you with the stigma plus claim? In fact, and more specifically, what is the stigma that you've alleged in the amended complaint, in the amended complaint, I believe, that would get you to the finish line, at least on this portion of the case?
Yeah, and so that would be the defamation claims from. So the procedure here was also.
Well, I know there's some defamation claims were wiped out. General defamation by the Supreme Court, correct? In the Mesnard case.
Not the defamation claims. The defamation claims were left in because they
on
weren't
the press
subject.
release. I thought that the only claim that was left was the press release.
The press release.
Others were barred by absolute immunity.
Correct. The ones related to the report were barred by absolute immunity.
And there's more out there?
Well, so the notice of claim, the original notice of claim and the amended notice of claim were, the AP picked up this story, and so there was the press release, but then there were also the various news media outlets that picked up this story, quoting Speaker Mesnard discussing this, and so that's what's referenced in the notices of claim, is these various press releases, and yes, they stem from a press release, but the damages occur at each publication.
But okay, so I'll just try to be more pointed on this. The cases that I've read, and there's a lot, quite a few out there, so I've not read them all by any means, but in the stigma plus area, which are not Arizona cases, obviously, they speak of this harm to reputation, and usually, or typically, what I saw was a defamation. They were harmed by defamation. But if we take that off the table, I mean, as far as the Supreme Court's taken part of it off the table on the report, the press release is arguably off the table, then what do you have left to support the reputational injury here?
And you're saying the defamation would be taken off the table because of waiver.
I'm just assumption.
Yeah.
I'm assuming it.
Well, I don't think the waiver would apply to the stigma plus claim, because the stigma plus
Well, I'm
claim
not
would
saying it applies. I'm asking what describe your stigma plus.
Oh,
claim
okay. So
on the facts.
yeah, so that's the press releases damaged Mr. Shooter. They were not protected by legislative immunity. And then the plus is that he had a protected interest in his employment as an employee of the state of Arizona.
But your press release damaged him how if there's no defamation claim left?
So that's where this, I'm weaving this, but it's correct, is that so if you find waiver on the defamation claim, because that's where the summary judgment issue was ruled on, and okay, fine.
Okay.
I mean, I'm not saying fine, but I understand your argument.
No concession.
Yeah.
No, but not a concession.
Yes.
But stigma plus, I understand, was part of the motion to dismiss.
Exactly.
Yeah.
And so that's a separate claim, which was appealed separately and not waived there. And so
I understood. I just want to know from what factual allegations support harm to reputation.
Oh, so that's that his reputation was harmed, and he because of his harm from his reputation, he wasn't able to run for re-election. He lost his employment, and that's where the harm is suffered. And
Even separate from the press release, could it just be the fact of being a removed, disgraced former representative where procedures weren't complied with?
That's
the
exactly
stigma plus.
right, and that's the other point is when this was occurring, and still today, it was very much caught up in a lot of the Me Too movement, and the opening brief, I'll admit, was used an improper choice of language in saying that it was in vogue, but that's part of this damage, is that he was wrongfully accused of actions that he maintains that he did not commit, and that led to his expulsion and his damages in this case because of the press release.
Maybe I misread the record, but it seemed like at least the ones that led to his expulsion were ones that he acknowledged, and I thought your argument was that they were kind of selectively prosecuting. It was stuff that everybody was doing.
Yes.
So it wasn't that he didn't commit the acts, it's just these weren't acts that were unusual at the time.
Yes, what I mean is that the wave of, in politics is very much, ebbs and flows, but he was caught up in that not for the reasons that were stated, but because there were ulterior motives here.
Gotcha. So let's say I agree with you, and I'm not saying I do.
No concession.
No concession from me either. I agree the Stigma Plus is something we should do and adopt, and it was abysmal, maybe, the way that the procedure was handled by the then speaker. How in the heck do I sit here as a Court of Appeals judge and say that 56-3 vote or whatever it was, we get to second guess that, even if it's just in the form of damages? That seems to be such a quintessential political question, especially following Puente. I don't see how I step into that mire.
Yeah, so it's not a political question because it goes to the heart of whether the Constitution was followed. And
The Constitution requires 2/3 vote.
yes, it does.
And that happened.
But it also requires disorderly conduct. And so then you go to the House's ability to, in the Constitution, to define its own rules, to set its members.
Puente just told us the House gets to do that. Set
Yes.
its own rules, define and police its own violations of its rules.
Absolutely.
And ignore its own rules. Or ignore state law in Puente. Ignore state law.
Judge Brown might have been on the panel that was reversed on that.
No, I don't think I was.
I don't know, it just seemed awfully fired up all of a sudden.
And so, but that's the issue here, is the Constitution requires disorderly conduct to expel a member. And the House does get to define what disorderly conduct is, but
Didn't they do that by voting 56-3? I mean, isn't that what we're to take from that vote, is that the members of the House decide what constitutes disorderly conduct, and they found it by voting him out?
I don't think so. No. And the reasoning is that the House had rules at the time that it took that vote on February 1st, and that defined what disorderly conduct was. The House then voted to expel him on that date, and then 7 days later.
What is that definition?
It is.
If you'd like to bring that up.
Yeah, I'll bring that up. I wrote
would
that
be
down,
fine.
so I
Thank
do
you.
have it. I'm sorry, the definition is not following the House's rules that are set forth. And so, but what...
So the House chose to implement circular rules.
Yeah, well, no, they have rules, and they have rules on decorum, but what I'm saying is they define disorderly conduct as not following these rules. And I'll get the exact language when I come back up. But the House rules that were in place at the time did not have the allegations in the House bill as an aspect of their House rules. And so that's the issue. Then later they passed the workplace harassment policy that did become part of the House rules. But that was after the fact of the vote. And so that's the problem here, is that the Constitution wasn't followed because disorderly conduct wasn't found. So that's where that nuance goes.
It wasn't found how?
Oh,
I mean, Did they say that they didn't find disorderly conduct? Didn't they implicitly find?
Perhaps, but disorderly conduct was not a term used in the House bill that was passed to expel.
Okay.
And so
And what law says that they would have to do that?
the Arizona Constitution says that for disorderly conduct and a 2/3 vote, they can expel their own members. And that's where what the House defines as disorderly conduct at the time of the vote is critical. Because then, essentially, the House could not follow the Arizona Constitution and come back and say, well, you know, we find XYZ is a violation of disorderly conduct. And
I guess I could see your argument if, let's say, the House specifically said, we don't find disorderly conduct, but we really don't like this guy, and we're voting to expel him anyway. That would be something you would argue that we could review?
It would, because I think it would need to be in the Arizona Constitution as a reason.
It would be like if the U.S. Senate said, it's not high crimes and misdemeanors, but we really don't like the last president, so we're getting rid of him anyway.
Yeah, I would argue
expect the Supreme Court to step in and say,
that's not a high crime and misdemeanor. And for the simple fact that the House is able to define.
So is that what you're
it
arguing
is.
they did? They said that they didn't find disorderly conduct, they just voted to expel him, and we can now step in?
I'm saying what they found was not disorderly conduct per the House's rules, which were required by the Arizona Constitution, and required both for the.
But they didn't say it's not disorderly conduct. They said, here's what we found, and you just argue it didn't rise to the level of disorderly conduct under the rules.
Right. I'm saying the actions that they found were not disorderly conduct under the rules, which are required by the Constitution.
Counsel, what about the case law, including the Snowden case from years ago from the U.S. Supreme Court that says public officials don't have any liberty or property interests in their positions? How do you resolve that? I mean, what's your justification to move the case forward in light of that precedent?
Of course, and to move that case forward, it's an interest in his position as an employee of the state of Arizona, not in a position, not his seat in the legislature. And so he has an expected interest for the remainder of his term, maybe not to be a legislative member, but for that employment and that position as an employee of the state of Arizona.
Sir, is there authority you have off the top of your head on that?
I'll remain my 3 minutes. I know it's cited in the briefing discussing different employees of the state of Arizona, and we also mentioned that there's not a lot of authority on this across the country because it's such a unique set of circumstances where a legislator is expelled without following the rules that are in place of the legislative body.
Thank you.
Thank you, Your Honors.
Good morning, Your Honors. May it please the Court. My name is Betsy Lamb. I represent appellees Kirk and Janae Adams. And Judge Perkins, as you noted earlier, we have 3 sets of appellees today. The appellees have agreed to divide our time between myself and Mr. Tully, who represents the Mesnards, and the state has agreed to forego its oral argument today. So I will do my best to keep an eye on the clock and save 7 to 10 minutes.
I was looking forward to hearing from the state because I recognize her from her time when she served as a clerk, not for me, but on the court.
Yes, for Judge McMurdy, I learned.
Yes.
But
I was going to ask her some really tough questions.
well, and she will give you fabulous answers, but hopefully I will as well. So I'm happy to answer whatever questions you have. Because there are so many issues in this case and that affect this appeal, which we briefed thoroughly in our answering brief, Mr. Tully and I have agreed to divide up the issues. The key issues that I will be addressing first are the threshold issues, which Judge Morse, you hit on right from the bat, which is this a political question or not? If it's a political question, the court cannot substitute its judgment for the judgment of the 56 members of the House who found Mr. Shooter's conduct to be dishonorable.
Is this a political question? I assume you're sort of cabining to
Yes.
the. Okay, I'll let you proceed on that then.
Yes,
It's
I'm
not
so
the
sorry.
defamation though, right?
Correct. So The two issues that I will be addressing are the threshold issues that affect Mr. Shooter's request that this court create a new state constitutional cause of action for damages for denial of due process. Before you can even get to that question, we have to first determine that it is justiciable, that it's not a political question, and second, that there isn't absolute legislative immunity. And we submit, Your Honors, that there is, that it's both a political question and Mr. Mesner's actions and the actions of the House are protected by absolute legislative immunity. Now, the pattern in this case, as Mr. Meyer recognized, this case has been going on for 4 years. We have had a myriad of claims that have been asserted over the past 4 years, which have been rejected by each court that has considered them, including the Arizona Supreme Court on
The Arizona Supreme Court left one claim.
Excuse me?
The Arizona Supreme Court didn't reject all of the claims.
No. It rejected the claim for defamation relating to the alleged defamatory statements made in the report from Sherman and Howard that Mr. Shooter alleged was then published by Mr. Mesner and altered by Mr. Mesner. But in reaching that conclusion, the Arizona Supreme Court, in that decision from June of 2021, made statements directly relevant to legislative immunity as applied to Mr. Shooter's third cause of action here for denial of due process. Because in reaching that conclusion, the court walked through the allegations more broadly in the complaint. I believe it's paragraph 20. The court said, look, conducting an investigation against a member of the House, that is a legislative function protected by legislative immunity. Paragraph 21, the court said, issuing a report, preparing a report and issuing a report regarding the results of that investigation. That is a legislative function protected by legislative immunity. And I don't believe Mr. Shooter denies that the introduction of a resolution to expel Mr. Shooter or voting on that resolution are equally political questions, legislative functions protected by absolute legislative immunity. So what Mr. Shooter does in his reply brief is try to reframe the arguments, and they are reframed in a manner that has never before been argued in this case in 4 years. So the reply brief, just as we heard today, argues that this court should not find absolute legislative immunity because Mr. Shooter alleges that the House violated its own rules, right? That's his argument in the reply brief. He then argues, look, you have this definition of disorderly behavior. That's something that this court...
But I would have thought that communicating with the public in regards to an ongoing legislative investigation is part of the legislative process as well. And our Supreme Court said no, that a legislative immunity, there's a line at the door somewhere that separates those two concepts. And so it didn't strike me as that unusual, their argument that they're trying to make. So what am I missing?
The argument that Mr. Shooter is trying to make that legislative immunity does not apply, I just want to make sure I'm understanding.
Well, there is some line at which legislative actions that would be subject to legislative immunity, that there's a line at which that ends, and going beyond that, and maybe violating your own rules or completely ignoring your own rules, as they allege, is the line?
So I would respectfully submit that is not the line. Okay, so there's several reasons. First, this argument that Mr. Shooter made what was made in his briefing before the Puente decision came out. The Puente decision makes very clear that it is up to the legislature and the legislature alone to determine its rules of procedure.
Be careful, because I don't want Judge Brown to get too upset.
To enforce those rules.
Wait, for the record, I don't know if he was on Puente or not.
I was not.
But that's a matter for the legislature to decide. So you cannot get around legislative immunity by claiming that the legislature hasn't followed its own rules. And in fact...
But doesn't this hold the fact that we're engaging in, I'm not trying to trap you at all, but doesn't the fact that we're engaging in this discussion, that there is a line, mean there is some point at which this does become justiciable?
So I think non-justiciable political question is different than legislative immunity. And
Isn't that the argument that Justice Bullock tried to make that the rest of the court kind of rejected, is that this should all be a political question, which sounds kind of right to me, as you can tell from my question earlier. But the Supreme Court seemed to disagree, saying, no, there's a line in which legislative immunity ends, and that's when the courts can get involved.
Well, it's interesting because I think what the majority said, which Justice Timmer wrote, the majority said, we didn't accept that issue for review, right? It wasn't before the Superior Court, and while Justice Bullock said, I believe this is a non-justiciable political question, the issue that the majority addressed was specifically the issue of absolute legislative immunity, which is what the Superior Court in the May 2020 ruling said it couldn't reach yet on this record. So that's what the majority did address in Mesnard v. Campanolo. But then in the Fan decision,
I cut you off. You were getting to Puente, too, so I'm sorry.
yes, well, in Puente, the Supreme Court did address legislative non-justiciable political question and did reach the same issue that Mr. Shooter is alleging here, which is whether the House's failure to follow its own rules somehow gets around the political question doctrine. That's the argument in his reply brief.
You agree that pre-Puente there might have been some wiggle room. I mean, Fan left some areas open, but Puente seems to foreclose a lot more than we had before that, doesn't it?
I think Puente does foreclose. I think it completely forecloses Mr. Shooter's arguments in this appeal, both on the political question doctrine and when we look at what are legislative functions that should be entitled to absolute legislative immunity. I think Puente is directly on point, and I don't see how, in light of the Puente decision and in light of the June 2021 Mesnard-Campanolo decision, Mr. Shooter can't overcome those decisions.
What about the failure to specifically call out or describe what the disorderly conduct was, like in the resolution? I mean, is opposing counsel correct that the resolution did not refer to disorderly conduct?
So that statement is correct, but the premise for it is not correct. So the section of the state constitution, Article 4, Part 2, Section 11, says the legislature may punish its members for disorderly behavior and may, with the concurrence of 2/3 of its members, expel any member.
And so that your argument is that's for any reason?
Correct.
Period.
Correct. And the precedent confirms that.
Let me push back about that.
Sure.
What if, heaven forbid, this would never happen, but if they said we don't like legislator X because of his or her race, court involvement or no?
I think technically, unfortunately, the answer is no. I know that's not a pleasant answer, but I think technically that answer is no. And when we look at the cases...
So your argument would be that they would need to turn to 1983 action in federal court, essentially, for that type of a situation? Or would there be? Would that person have any rights?
No, I think that would be absolutely the correct path. And I don't know in that situation how the legislature could claim qualified immunity, which was the issue in this case on the 1983 claim. So I think it would be a separate cause of action. But when we look at what the legislature did find here, they may not have used the magic word, even if it was required, which I do not believe it's required. Even if they didn't use the magic words, 56 members of the House found his conduct was dishonorable, unbecoming of a member of the House, and undermined the confidence of the public in the institution.
And I am acknowledging I probably haven't looked closely enough at the actual resolution recently, but is that actual language they found, or is that implied from the finding?
That's the actual language that they found. It's House Resolution 2003. It was attached as an exhibit to the motions to dismiss and accepted by the court on the motion to dismiss.
Thank you.
And I can get you the IR number if that would be helpful. Okay. But no, it is the exact language of the House resolution where it was dishonorable, unbecoming, and undermined the public's confidence in the institution. The other key thing to look at here is when we look at historically, and we didn't raise this in our answering brief because, frankly, the words disorderly behavior and an argument that we hadn't satisfied that or that the legislator hadn't satisfied that is not an argument that's ever been made before. But after getting the reply...
I'm sorry, let me go back for just a second.
Sure.
Do you have any authority for your proposition that you argued earlier that those are effectively disjunctive, that they can punish for disorderly behavior and they can expel you for any reason regardless?
Yes. So I did some research after getting the reply to try to dig into what that argument could even possibly be based on. And there's a decision from, I believe it's the Second Circuit in Montserrat, that says there's not much guidance for what disorderly behavior is, and it's not clear that that's a limit on expulsion. And then if we look back even as far back to In re Chapman, which is a U.S. Supreme Court decision from 1897, even there the court said the right to expel extends to offenses inconsistent with trust and duty of a member and is not bound, it didn't bind it by this disorderly behavior language, which is similarly in the U.S. Constitution as the Arizona Constitution. So there has been no court that has addressed the expulsion of a member of the House or the censure of a member of a House that has looked into what does this disorderly behavior even mean, nor recognized it as a limitation on the expulsion power. Instead, the courts that have addressed a legislature's either investigation and censure or expulsion, both of which were cited by the Supreme Court, I believe, in the Mesnard v. Campanolo case. We have the Rangel v. Boner case, which is from the District of Columbia, in which there was an investigation and censure of a member of the House. He challenged that, arguing, just as Mr. Mesnard argues here, a violation of the rules and a violation of due process. The district court found that's barred by the political question doctrine and absolute immunity. On appeal, the D.C. Circuit affirmed and said that's barred by absolute immunity. Then we have the District of Michigan in the Gamrat v. Alred case, which in 2018 involved another investigation and expulsion of a member of the House. That case as well found the claim to be non-justiciable. So we have every case in which this has occurred, or virtually every case in which this has occurred, the courts have recognized these are issues committed to the legislature. We cannot wade into that decision and substitute our views for how this process should have played out. That's for the legislature and the legislature alone to determine. And unless you have any questions, I will turn it over to Mr. Tully because I don't want to eat into his time.
Thank you.
Good.
Thank you so much.
Thank you and good morning. Steve Tully, representing the Mesnards. I'm just going to address two issues, hopefully fairly rapidly. The first issue is the due process claim that they're making now. It was dismissed because Mr. Mesnard or Mr. Shooter failed to state a claim, and that was absolutely correct. The court was absolutely correct in that because Mr. Shooter did not allege a due process violation because he did not allege an infringement of a property right, a property interest protected by the due process clause under the Arizona Constitution. It is well settled law that politicians have no protected property interest in their office. The Arizona Supreme Court has directly ruled on that issue in the Meekum v. Gordon case. The failure to allege a protected property interest affects all of Shooter's claims. I know now he's just seeking a due process claim under this stigma plus basis, but without a due process property interest, you don't have a due process claim under any theory. So there's no reason for this court to even consider adopting a new theory because he hasn't alleged a claim, a due process violation, without a due process property right. And this, again, applies to every claim he's made. He's asserting a stigma plus claim, but that does in no way alters the analysis. Stigma alone is insufficient to state a due process claim. That's the Paul v. Davis case, in which the U.S. Supreme Court held that injury to reputation is not a liberty or property interest protected by the due process clause of the 14th Amendment, and therefore reputational injury alone does not represent an actionable claim under Section 1983. Therefore, as stated in our brief, Mr. Shooter alleges a stigma in being discharged, which is not a due process claim.
Would you agree he's adequately pled a stigma?
He's pled a stigma, right, yes, but he has no plus. There's no,
What is the pleading of the stigma? What is the stigma?
well, he claims he was, what he actually alleged in the notice of claim was that he was stigmatized by the report that was produced and it led to his being discharged from the house. That's what's in the notice of claim. That's what he initially pled in the suit. And as we know, the Arizona Supreme Court has said that's not a claim. That's barred by absolute legislative immunity. And so that was his claim. But stigma alone is not a claim. It's not a due process claim. And stigma plus no property interest, which is black letter law, is not a claim. It's not a due process claim. So the analysis really doesn't need to get any further than that. He's not stated a claim, a due process violation claim under any theory, 1998, 1983 or otherwise. The next issue, of course, is the defamation claim, and that was granted, summary judgment was granted on that claim. And the Superior Court granted summary judgment on that claim because Mr. Shooter had not complied with the notice of claim statute. He did not, as the court already addressed, he did not address the statute of limitations issue in his opening brief, and in response, he really didn't respond to it, I think, as Judge Morris noted.
How did this claim not relate back? I mean, if he alleged defamation in the original complaint, how's that? Don't we view relation back, is it Rule 15, whatever, amendments fairly broadly?
No, that's not in defamation cases. The defamation, as the court has stated in State versus Superior Court case that we've cited, defamation, every instance of defamation is different, is a separate action, and they do not relate back. So, the fact that, someone called me a buffoon on Monday doesn't relate to, calling me an idiot on Tuesday or
It's just opinion.
Right, well, it's just opinion, happens a lot around here. So anyway, in any event, so the case law in Arizona says that they will not relate back for purposes of the rule. Defamation claims, they have to be stated, and since it wasn't stated in the initial complaint, the time ran, and the court properly dismissed it on that basis. And they don't really, as mentioned, they don't really argue that case. I mean, they kind of say it's non sequitur. Their argument in the reply is just, well, it's a notice pleading state. Okay, but that doesn't really. I mean, that's the problem. There was no notice. They didn't make any arguments related to the press release at issue. And because I got 20 seconds left, I got to be very quick. But I want to be clear. The notice of claim didn't reference this press release. The only press release that they cite was a separate press release. The press release at issue and all the facts relating to the press release at issue, none of those are in the notice of claim, not one. And so the notice of claim had nothing to do with did not at all. I'm out of time. Thank you.
Counsel.
I will say for the record, Mr. Tully is not a buffoon. So a couple things. One, with regard to the waiver argument, the opening brief tackles the Superior Court's ruling on the motion for summary judgment that, yes, while it's two distinct issues and rulings, they're both related to the notice of claim and ARS 12-821. And
So walk through that for me. So
Yeah.
is the argument then that because the Superior Court found the notice of claim to be faulty, that impacted the separate finding that the statute of limitations for the time in which you filed it after the notice of claim?
That's correct.
How?
Okay, so the first, as to whether the notice of claim adopted the claims for defamation, and then the second for whether it was timely. And so what the opening brief does with regard to this motion for summary judgment is goes through the entire notice of claim, showing exactly how that first argument is
I
wrong.
agree with that.
And because it's wrong, it's inherently timely. And so that's the argument that's captured. And so while the word timely doesn't appear in the opening brief, it's captured by two.
But counsel, a litigant can clearly meet the notice of claim requirements and utterly fail to meet the 1-year requirement in which to file a lawsuit.
Correct. But that,
And didn't that happen here?
no, what happened here is that there was a notice of claim, a complaint, an amended notice of claim, and an
I
amended
understand
complaint.
that,
And so-
but treated it, but how did, weren't you obligated to argue that in your opening brief?
It could have been clearer for the court, but with regard to that summary judgment ruling, it's identified as two separate rulings, but they can be argued with one argument.
Okay, assuming we don't find it waived, what about Mr. Tully's argument that defamation, the case law plainly suggests or states that you have to plead defamation with specificity? Wouldn't it be akin to like fraud?
No, it would not be. It's what Mr. Tully's argument is that you need to plead each separate. You can't just say there was defamation on January 1st and then say that also includes the
But when was
defamation.
the press release ever pled?
Well, so what was pled is that, or what was in the notice of claim is that there were various news
The
releases.
Mesnard press release. When was that pled?
So that was pled with specificity in the amended complaint completely, but what it's captured, and this is in some of the reply briefs, and my time's up, but this was in the reply brief where it shows the notice of claim and then shows the exact phrase that was used in the amended complaint. And if I could make one
Nope.
additional...
Thank you very much for your arguments. Your time has run. We appreciate your briefing and your time before us today. We'll take the matter under advisement and issue our decision in due course. Court is adjourned.